For today's story, we're discussing a racketeering operation in cheerleading prurient abuse, a scandal that has infected both South Carolina and now North Carolina, as a lawsuit claims that various gyms have turned a blind eye to a coach's repeated abuse of a teenage boy. Let's go ahead and get started with this nightmare. A cheerleading abuse scandal, once confined to South Carolina, has now gone north of the border and is now infecting North Carolina. In a sprawling racketeering complaint, the plaintiff was a teenager at the time he was allegedly abused by coaches at Cheer Extreme gyms in Raleigh and Kernersville, North Carolina, as well as a choreographer approved by Varsity Spirit LLC and the United States All-Stars Federation, which is a nonprofit student-athlete standards and coaches credentialing organization for competitive cheer and dance. According to attorneys in a press release, they are seeing a pattern. These entities have had every chance to protect their athletes from these prurient predators, but until a family goes public, nothing happens. It turns my stomach every time. Yeah, this sounds suspiciously familiar, as we remembered from the Olympics scandal a couple years back with Nadler. And it looks like maybe it's not. Yeah. The alleged victim, who's apparently who's bringing this all to light, began cheerleading in 2013 when he was 12 years old and attended his first Cheer Extreme event when he was 14 or 15. After the clinic, the teenager transferred to cheering for Cheer Extreme in Raleigh on their Elite Worlds team. During the first year of cheering for Cheer Extreme, when John Doe was 15 or 16, an older male coach initiated a prurient relationship with him. The coach had previously contacted John Doe via social media and Snapchat while John Doe was cheering for his former team, but they never officially met one another until John Doe began cheering for Cheer Extreme. Well, it sounds like he was being groomed with social media. The original petition states some details of the abuse. On regular occasions, the plaintiff, John Doe, would hang around socially with the older coach and other coaches, owners, and administrators from Cheer Extreme, including defendants Kelly Helton and defendant Chase Burris and Sean Wilson, where the coach would caress plaintiff John Doe, hug him, and touch him in front of the other adults. Exciting and fun, and not at all disturbing in any way. On at least one such occasion, the adult coach pressured John Doe to use cocaine. Plaintiff was 16 or 17 at the time. Around the same time, a coach from Cheer Extreme, Kernersville, found plaintiff John Doe on Snapchat and began sending him nude photos. Grooming of a minor by the cheerleading coaches. Great. In 2016, at a cheer competition in Indianapolis, according to the lawsuit, the Kernersville coach arrived at the teenager's hotel under the influence of alcohol after messaging him on social media about spending time together. The coach insisted that John Doe get into the coach's vehicle, after which time the coach proceeded to drive around, eventually stopping and forcing John Doe to perform oral acts. The Kernersville coach trying to push John Doe into having more intimate relationships, but apparently John Doe did refuse that. The next day, according to the lawsuit, the teenager was forced to see the coach, who forced him into, again, having oral relationships before a competition. The filing goes on to allege that the choreographer affiliated with Varsity and the United States Federation invited the boy when he was 17 years old into a hotel room and propositioned him for acts that the boy refused. Premised on liability under federal law that imposes a duty on adults who are part of national governing bodies such as athletic organizations, the filing also presents a theory of enterprise liability under RICO. So federal law makes these people mandatory reporters because they are a national governing body. So federal law also applies and makes them mandatory reporters. So their failure to report, including incidentally on themselves, means that they're violating that law. And certainly with respect to the other people. Yeah. The filing further goes on to allege that the enterprise, as previously described, consisted of a group of persons associated together for a common purpose of recklessly, intentionally, and willfully endangering the plaintiff as a minor athlete by exposing him to illegal prurient abuse and exploitation, while continuously and repeatedly taking money from him, and also ensuring his parents and guardians he was safe in order to take this money. The defendants, and all of them in concert with this illegal enterprise, were engaging in misleading and fraudulent messaging to the children and families, which they knew or should have known was not in a position to discover the damages, since the defendants were concealing it and failing to report it, acting in reckless indifference to the safety of the children in the name of money. The lawsuit goes on to allege 9 other counts of action, including assault, battery, unjust enrichment, fraud, conspiracy, gross negligence, negligent supervision, and a violation of North Carolina Consumer Protection Law, among other things. Thus, that brings us to what seems to be the start of a very, very disturbing iceberg. A boy who was very much a minor was abused, apparently, by his coaches and choreographers and others. He wanted to be a cheerleader. He started taking cheerleading classes when he was 12 or 13. Okay. And apparently was exploited and treated with in horrible, horrible ways. And this probably is just the start of trying to expose this, because it probably didn't stop with him, now did it? So yeah, it looks like we're heading down this track again. Larry Nassar apparently isn't the only one. This is disturbing. At least for a moment, that brings us to the end of discussion of this tale.